your appearance is on.
Brian Ziegler on behalf of the Your Honor.
Kyle Travis on behalf of Mr. Flowers.
This is the date and time set for sentencing in this matter. Mr. Flowers, have you had an opportunity to go through the pre-sentence report and talk to Mr. Travis about that?
Yeah. Yes, I'm sorry.
Mr. Travis, are there any additions, deletions, or corrections to that report?
Not anymore, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, this was a plea that was reached between the parties as sort of a pseudo 7411 agreement. It was using to myself and Mr. Travis that even though we believe that he has a conviction for possession of marijuana that was expunged, it doesn't appear in the PSI, but we do believe he has that conviction, and we do believe it does make him ineligible for 7411. But I think other than that, Mr. Flowers is very likely to do well on probation. He has no other criminal history that we're aware of. I think that makes him a good candidate to successfully complete the terms of his delay, and I hope he takes full advantage of those terms.
Mr. Travis?
Thank you, Your Honor. Yes, I think the PSI very much makes the argument that the delay that Mr. Ziegler offered and that Your Honor accepted it is appropriate in this case. Mr. Flowers has had some troubles as of late, as indicated in the report. He's moving forward with that. Got to take more notes, got to plan the day out better. But he's doing well. I think he will do well on this probation. He's taking it seriously. He's motivated to do well. So we would ask Your Honor to follow the recommendation.
Mr. Flowers, anything you wanted to say?
I'd just like to acknowledge that I know what I did was wrong. I had up my butt, for lack of a better term. I would also like to thank the prosecution for going out, finding a better sentence or sentencing for me, so that I did not qualify for the 7411. I appreciate that. I just want to move forward from this, and everybody's here.
All right. Well, I hope that's the way it goes. That's what we're all hoping, I think. And you're gonna have an opportunity to do that through this delay of sentence. And I think under the circumstances here, the lawyers have indicated the reasons why, and I agree that it is an appropriate resolution. It's going to give you an opportunity to avoid any kind of jail time in this case. And if you're not successful, I'm sure Mr. Travis has gone through the guidelines with you. There's a potential of up to 6 months in jail. So I hope that provides an additional motivation to you to comply. So the court is going to follow the recommendation and the agreement and put you on a delay of sentence for 12 months. The court is going to adopt as the conditions of that delay all the terms and conditions listed in the report, and that includes not using or possessing any controlled substances unless they're prescribed to you by a physician, as well as all the other terms and conditions which your agent will go through with you. In order to get the benefit of the delay here, you'll need to, before it's over, you'll need to pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, along with a fee of $30 per month during the delay for supervision. The court isn't going to address any jail time or jail credit at this point, given that this is a delay. So Mr. Flowers, it's very important that you go through this with your agent. Ms. Wagner, I know Mr. McFalda is the one who did the PSI. Are you going to be the supervising agent here?
Yes, if he can come over to the office, I'll get him set up with reporting instructions. Thank you.
Okay, so just check in with Ms. Wagner before you leave here today. And, again, it's very important to stay in touch with her and make sure that you're complying with all the terms, okay?
Okay.
Do you have any questions at all?
No, sir.
Okay, good luck going forward. Thank you.
Thank you.
Thank you, Your Honor.
Mr. Williams, were you ready with Ms. Green's case?
I am, Your Honor.
Okay. People versus Heather Green, file number 255053. The record should reflect Ms. Green's present here in the courtroom today. If counsel can take your
Jesse was signing this week.
This is the date and time set for sentencing in this matter. Ms. Green, have you had an adequate opportunity to go through the report with Mr. Williams? Mr. Williams, are there any additions, deletions, or corrections?
No, Your Honor.
And are there, this is the one you're looking at, no guidelines. Mr. Sigler, do the people have any additions, deletions, or corrections?
Yes, Your Honor, on page 2 and page 4 in the recommendation narratives regarding the restitution. At both those places, it says that the restitution is payable to the state of Michigan. It's somewhat of a moot point because the restitution's been paid in advance, but that's not accurate. $15,808.50 of that was payable to the Social Security Administration at the federal level, and the remaining $4,899 was payable to the state of Michigan. So it was payable to the state of Michigan and the Social Security Administration.
All right, thank you. We'll make that correction. Any other corrections?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I think the recommendation in this case of a brief, straight jail sentence is probably a fair and appropriate outcome. Ms. Green claimed benefits she was not entitled to from multiple different government agencies, state and federal, to the tune of over $20,000. This was not an isolated incident or an accident. She repeatedly told the Department of Health and Human Services that her daughter was residing with her when she knew that her daughter was in an alternate placement, and she was provided very little in terms of her actual care. Later, she applied for Social Security benefits and for RSDI benefits on her daughter's behalf. She forged her daughter's signature, and she did not provide any of those benefits to her daughter. To her credit, however, she's made full restitution to the government for these overpayments. I did receive checks from the defense about 3 weeks ago, and I've dispersed those to the relevant agencies. So all of the restitution is paid in full at this time. I don't believe probation is necessary or appropriate under these circumstances. There's no need to monitor her payments, and there's very little to be gained from her regularly checking in with the state. She's either learned a lesson from all of this and she's not going to do it again, or she has not, and probation's unlikely to change that either way. However, I do think some punishment is warranted to let others in the community know that you can't simply defraud the government and then skate entirely if you pay that money back later. I'm sure this has been a long and difficult process for Ms. Green, but I think a jail sentence is warranted in this case, Your Honor, if for no other reason than simply to deter other members in the community who would consider engaging in similar actions. The fraud at issue was significant, but she has no prior history and she's made full restitution. I think a sentence of 30 days is a reasonable balance given all of that, Your Honor. So that's what I would ask the court to impose.
Thank you, Mr. Williams.
Your Honor, may I approach? I just have 2 short letters that were
Yes.
provided today. I did present them.
Thank you. Did you want these back?
Sure.
All right, Williams and Tenney. And then anything for allocation.
Thank you, Your Honor. I mean, I don't know about people defrauding the government and skating. It's a wild world we live in these days, but the family's always complicated, always layered. She's taking care of one family member. She's got a disabled other family member. She paid everything back in full. I don't believe that putting her in jail, the recommendation, I believe, was 9 days, but incarcerating her certainly is not going to deter the next person who is financially strapped and juggling different family members with different problems. That is that she was out vacationing and living some luxurious life at the government's expense, flying around on airplanes and other things. I agree that probation doesn't make sense. She comes before the court with no record whatsoever. She's a primary care provider for her mother, and she's making ends meet in life. I would just ask the court to censor fines and costs at this time. I really don't believe that incarcerator will deter anyone in this similar circumstance, nor do I believe it serves any purpose to her. I mean, this case has been going on for some time. We've adjourned it so she can make this money back, and now just to put her in jail, that doesn't make sense. If we look at how a felony is treated, just statutorily, she's in a presumptive no jail sanction. And she's, it's a misdemeanor, but 0 to 18 months is presumed no jail. So just to incarcerate her, just to punish her, I really don't see how that's a value to anyone at this point. So I would ask you to censor fines and costs, Your Honor.
All right, thank you, Ms. Green. Anything that you wanted to say? Okay. All right, Ms. Green, I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your circumstances and your background. I take all of that into consideration along with what the lawyers had to say here today. And looking at the circumstances as a whole, I think sometimes people fall into this trap where they see a way that they might be able to get some extra funds. And I think a lot of people are legitimately in need of money. And I think they tend to engage in these kind of crimes when they don't think that this is going to get found out. In other words, that the bureaucracy is just so big with all the cogs and the wheels that it's just not something that's going to be discovered. And so I think that's an added temptation between the needs that they may have and the thought that this is money that they could get a hold of without any repercussions. And from what I read, I think that's what happened in this case. It may not be, but from what I read, that's what it looks like to me. You don't have any prior history. You did make efforts to repay all of the money. I think those are both factors that work in your favor. Obviously, your conduct in this case is something that works against you and that the court finds is something that requires the imposition of some type of punishment. In this case, and in every case, the court has at its discretion the ability to impose jail time as a punishment. Financial punishments are also an option that the court has to employ when it finds that jail time isn't appropriate. In this particular case, the recommendation is for 10 days. The prosecutor is asking the court to impose 30 days. Your attorney is asking the court not to impose any jail time. And in my view, I think a short jail sentence is appropriate in this case. For somebody that's never been to jail before, which I don't think you have based on the information here, it can be a very significant experience that I think would impress upon you that this is not appropriate conduct. And I don't think it needs to be a 30-day jail sentence. I think for somebody that hasn't been to jail before, a shorter sentence can drive that message home. And I think it is something that's necessary in this case, given the amount of money and the circumstances, that there be this punishment. I do think it does serve as a deterrent if people know that it isn't a situation where you just pay back the money and everybody goes on their way. So for those reasons, I do find that a jail sentence is appropriate. The court is going to sentence you to 14 days in the Kalkaska County Jail. You do have credit for 1 day served. The court is going to order restitution, but that's already been satisfied. The court is going to order a crime victims assessment of $75, court costs of $325, a DNA testing fee of $60, and a $53 state cost. You do have the ability to seek an appeal of this sentence. If you wanted to appeal this sentence, you would need to file for that appeal within the next 21 days. If you have additional questions about that, then you could ask Mr. Williams. I'm sure he would be able to explain that process to you. Otherwise, you are going to be remanded to the custody of the county at this time. Mr. Ziegler, anything further further on this file today.
No, Your Honor.
Mr. Williams?
No, Your Honor.
Okay, thank you. That's all for this. Did you want these attached to the PSI?
Thank you, Your Honor. Yes.
So we'll go on the record in People versus Hyatt, file number 255139. The record should reflect Mr. Hyatt present here in the courtroom today. This is the date and time set for sentencing. And pardon me, Mr. Hyatt, did you have a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes.
Mr. Travis, are there any additions, deletions, or corrections?
Not that I'm aware of, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, people have any additions, deletions, or corrections?
Yes, Your Honor. Under the description of offense, second page of the description of offense, about the middle of the page, there's a paragraph that starts with the male driver was subsequently identified. In that paragraph, there's a parenthetical statement that says bases for OV 14 as Hyatt was driving in a multiple offender situation. I would ask the court to strike that. OV 14 was not scored in this case, and I think correctly so. It was not scored because the passenger in the vehicle was not an offender. So I would just ask the court to strike that reference to a basis for scoring OV 14.
Any objection?
No objection, Your Honor.
Okay, we'll make that correction. Any other changes?
No, Your Honor.
Anything on behalf of People for Allocution today?
Your Honor, I think the recommendation in the report for prison is clearly appropriate in this case. Mr. Hyatt was on parole and he was on bond for another felony matter out of Andrew County when state police attempted to stop his vehicle. He fled from Trooper Tabatas. Another officer, Deputy Ray Ferrier, also attempted to stop his vehicle and he again fled from that officer, ultimately crashed his vehicle into a tree. Luckily, despite fleeing from multiple officers and crashing his car, no one was seriously injured as a result of his conduct, but they very well could have been. His guidelines are 10 to 23, which in my mind strongly recommends a prison sentence. And the fact that he was already on parole and committing multiple felony offenses while on parole only underscores that, Your Honor. I would ask the court to sentence the defendant to 18 months prison consecutive to any parole violation.
Thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, as you've seen, Mr. Hyatt's doesn't have the best record. It's actually starts with juvenile issues, and he has been to prison before. He is on parole. We understand that the conduct is not encouraging. Mr. Hyatt did, take his offer, plead guilty, and has acknowledged his behavior was inappropriate. As noted in the PSI, he's under sentence out of Antrim County for a narcotics case. I do think Mr. Hyatt's got a raft of problems that started in his youth. Clearly, he's been, remorseful, appropriate, and not denying reality this whole time, which I think is nice to see from someone with his history. Truthfully, we initially had planned to ask Your Honor to give him a county time sanction. I realize that is at the bottom of the guidelines, but it is within Your Honor's purview. In talking more about that and realizing his status, I don't know, and I know this is not necessarily Your Honor's main focus is what's best for Mr. Hyatt, but not knowing what MDOC is going to do, I don't know that would necessarily not actually cause more problems for Mr. Hyatt. I'm really not sure. If MDOC wants him to go to prison, they have the chance to do that. And if Your Honor doesn't send him, they might well do that. As I was telling Mr. Hyatt, by no means is it this is what happens, but oftentimes speaking with clients and after the fact, if they're satisfied with what comes out of the trial court, they'll just, stack the tails and kind of leave it at that. So, I know Mr. Hyatt wants to move forward from these things and try and be productive and get back to his family. He's got letters of support and other support here in the courtroom. But I generally don't know what would be best for Mr. Hyatt. I know that's not the court's primary concern. Would that be a county time sanction or a prison term? So I can't tell him, because the reason I talk about all this is there's still a large unknown of what MDOC is going to do. That hasn't happened yet. So we would ask Your Honor to give what you feel is an appropriate sentence. Thank you.
Thank you, Mr. Hyatt. Anything you wanted to say today?
Yeah, past juvenile records messed up. Adult record messing up. I should have stopped when they flicked me, but I didn't. Seen them cowboys come back on, I wasn't trying to go back because I was on parole from Antrim County. And all I asked, I got family out there that's not doing good. All I asked for maybe a little bit of lenient on time.
All right, well, I read through the report, so I'm familiar with the circumstances of what happened here and your actions that bring you before the court today. I'm also familiar with you, generally your background and your circumstances based on the information in that report. So I take all of that into consideration. I did get the 2 letters that I read here just shortly before the hearing started. And also what both the lawyers had to say and yourself. I might try to take all of those things into consideration in determining what is an appropriate sentence. I think to the extent you have family here that aren't doing well, you've had an opportunity to remain out of jail or prison through your parole, and this incident took place and you made the decisions that you made. And so while I certainly sympathize with them and understand what they would like to see, ultimately it's your decisions that put you where you're at. And the further you go down this road, the less opportunities there are going to be for you to remain local and to get community sanctions. And in this case, your actions here put the officers in danger, they put yourself in danger, put your passenger in danger, they put other innocent people who had nothing to do with this, who were out on the road at this time, in danger. And that's something that I think the court has to take very seriously. Because it's clear to me that regardless of what your family's needs are, that you're making decisions about what you think is going to be best for you in that moment, regardless of whatever harm or danger it puts other people in. And that includes later on down the line. And so to me, that tells me that you're in a position where the court has to be concerned about public safety, because you're going to put what you think is going to be expedient for you in that moment ahead of other people's safety. Given your past history, given your status on parole during this incident, where had you just pulled over, maybe you get a civil infraction for no license plate or something like that. You turn this into something that it really didn't need to be, in addition to the danger that you put everybody else in. So for those reasons, the court finds that a sentence at the top of the guidelines is reasonable, it's appropriate, it addresses your conduct in this case and your past history. The court is going to sentence you to the Department of Corrections for a period of 23 months to 5 years. Because of your parole status, you don't have any credit. The court is required to make the sentence in this case consecutive to any parole sanction. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and we're going to provide you with some papers that explain to you what your rights are, as well as how to request a court-appointed attorney to help you with any appeal. Mr. Travis, if you can just let me know once Mr. Hyatt has acknowledged receipt of those rights. I are remanded to custody of the state at this time. Do we have Miss Massey present?
We do, she's just outside, I think.
If I could have Miss Massey come up to the podium, please. People versus Massey, file number 255145. Record should reflect Miss Massey is present here in the courtroom today. If I could have counsel.
Ryan Ziegler, on behalf of the people, Your Honor.
Kyle Travis on behalf of Mrs. Massey.
Mr. Travis, can you tell me the status of this file?
Your Honor, we did waive the preliminary exam based on the offer to resolve the matter under 7411. I've had not a lot of conversations with Ms. Massey individually and speaking with some family members yesterday, actually, started to have some concerns about how she's doing mentally. Just to be frank with the court, was considering requesting competency. I've spoken to her today. I'm not making that request right now, but I would ask for the adjournment for her and I to talk some more, because I'd like to get a more informed handle on whether we want to do that.
Mr. Ziegler?
I have no objection.
All right, I think that's a fair request. This case was found over not too long ago. The only thing, I will set it for another status conference in 30 days. The only thing, Mr. Travis, that I would request is if you have your discussions with Ms. Massey, you make the determination that you need to submit this for a competency review, that you don't wait for that hearing. We can get that ball rolling sooner. And I think the sooner we do that, the better. So, and if you determine that that's not an issue, then we're fine going forward at that next status conference.
Thank you.
Do you have any questions about that?
No questions.
Okay, Mr. Ziegler?
No.
So Miss Massey, you just need to make sure you stay in touch with your attorney and have some discussions with him, okay? Do you have any questions about that? All right, thank you.
Thank you.
Thank you.